They say winning a lawsuit is half the battle. Let me tell you about companies who don't show up for court and they let you win. Now, this is a procedural gamble that the defendants take when they allow this to happen. For then the court will issue what is called a default judgment and sign an order granting a judgment against them. So anything that I share comes from actual personal experience, and this is not legal advice. Now, before you start running and celebrating that you won, you must consider two important things. First, you don't know who the company banks with, or specific assets or a portfolio. You see, a judgment, no matter how favorable, remains an uncollected debt. Now, let me say, letting you win is a gamble because you might figure out the Rubik's Cube of collections and get to what's owed to you. Some companies use this as a strategic pattern that they are often betting on that the plaintiff lacks the persistence or technical knowledge to navigate the post-judgment discovery process, and their belief that the plaintiff won't have the resources, knowledge to track down the assets to enforce the judgment. They consider this an ace in the hole. Remember, there is a process to all this, and if you want to collect your judgment, you must follow the steps to collect. You see, you have hit on one of the biggest realities of civil litigation. Winning a lawsuit is only half of the battle. Obtaining a judgment is when the real battle begins. So now, the winner must effectively assume the role of a detective because he has to locate the assets. Then he has to be a lawyer because now he has to understand the procedural rules of execution. That means trying to collect that money. And number three, he becomes a collection agency because he has to enforce the judgment. You have to do all that just to collect a judgment that has been awarded to you. Now, as noted, the burden of collection shifts entirely to you. A judgment creditor must initiate a supplementary proceeding, and it's called a post-judgment discovery, to unearth assets needed to satisfy the debt. Now, here's how the legal process works to find the money after securing a default judgment. Number one, it's called a post-judgment discovery. You have the legal right to force the company to reveal its assets. You can serve the corporate officers with a post-judgment interrogatory or written questions, or a deposition subpoena requiring them to appear under oath and produce bank account numbers and statements, real estate deeds and property titles, accounts receivable, who owes them, the returns, and financial statements. Now, if the company ignores the discovery request, they risk being held in contempt of court, which can escalate to fines or even arrest warrants for corporate officers. The next is called a writ of garnishment, and this is going to be associated with the bank. Once you identify the company's bank, you don't have to ask the company for the money. You file for the writ of garnishment directed at the bank itself. Once served, the bank is legally required to freeze the company's account up to the amount of your judgment and transfer those funds directly to you or the clerk. Number three, this is called a writ of execution. Now, I did a video on a writ of execution, so if you want, you can probably click and see writ of execution, and it allows you to seize physical assets. So if a bank accounts are dry or hidden, you can request a writ of execution. This authorizes the local sheriff or marshal to physically go to the business location and seize tangible assets, inventory, equipment, vehicles, computers, and sell them at a public auction to pay off your judgment. Then the next thing is a judgment or a lien. For long-term pressure, you can record the judgment in the county where the company owns real estate. This requires a judgment lien against their property. They cannot sell, refinance, or transfer the property without paying you off first. And securing the judgment gives you the legal authority to act, but executing a smart post-judgment strategy is what actually forces a company, a corporate defendant, to pay promptly. Now, one thing I do want to tell you, if you have a judgment in Tennessee, but you go to New York, that is what you consider as a foreign judgment. Now, what a foreign judgment is, and I had to learn this, is a judgment that's not within that state. Now, how do you get a foreign judgment to not become a foreign judgment? It's really quite simple. You go to the clerk and you pay the clerk's filing fees. You, whatever it costs, $200, it costs $300. You pay that, the money, to file it in that court. And once the court accepts that money, they stamp it. It now becomes New York judgment, a Texas judgment. So any place you are in the United States, or even in another place, out of state, out of country, if you have a judgment against a company, you pay the court costs, and now it's no longer a foreign judgment. It becomes an actual judgment, and it's executable. Now, I hope that the information I gave you was helpful. And if you did like it, maybe subscribe or pass it on to some friends. Because believe me, I'm not the first and won't be the last that something like this has happened to. And so the more chances that you know how to collect your money, so if you have to take somebody to court, you don't have to fear the unknown. I went through it and I understand it. And so everything that I told you, I've done it in one way or the other. Thanks for stopping by. Unc out. Peace.